Rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Nous sommes en audience publique, Monsieur le Président.
We are in public session, Your Honor.
Much. The chamber will deliver its ruling on the motion argued earlier this morning. The defense made a request for disclosure of, first, all costs expended by the Victims and Witnesses Unit for purposes of relocation, maintenance, and or support of Witness 268 within the Witness Protection and Support Program. That is the first limb of the defense request. The second limb of the request is the disclosure of any evidence tending to show fraud or rather acts of illegality on the part of the witness that bears a direct connection to his maintenance and support within the Witness Protection and Support Program. The legal basis of the defense request are alternatively the Chamber's decision of the 4th of September 2013 entitled Decision on Disclosure of Information Related to Prosecution Intermediaries, or alternatively Article 67(2), which requires the prosecutor to disclose information which may affect the credibility of prosecution evidence. The rational basis for the request, of course, is that the request may affect the credibility of the witness. The OTP does not oppose the second limb of the request, but they do oppose the first limb of the request. So too, as we understand it, does the VWU. The reason for opposing the request is that the VWU is an independent unit tasked with making independent judgment on what is appropriate in terms of costs to be expended on witnesses' sustenance or maintenance, witnesses that are within their care. And as such, all efforts are made to ensure that those costs are reasonable and not inordinate. The Chamber grants the request in part only, and only as regards the second limb of the request. The Chamber denies the request in all other respects, in particular as regards the first limb of the request. In the Chamber's view, the probative value of granting the request in the first limb is outweighed by both the considerations of prejudice and efficiency, not only in relation to the witness, but also the operations of the Victims and Witnesses Unit and the administration of justice in general. Witnesses who come to testify, it is presumed, will have to have sustenance in their lives, whether it is afforded to them on their own or through the instrumentality of the Victims and Witnesses Unit. It therefore does not afford a prima facie indicia of credibility that the Victims and Witnesses Unit has undertaken those reasonable tasks of providing reasonable support and maintenance to a witness rather than the witness doing it themselves. That is the ruling of the chamber.
As the court pleases, Your Honours. I know that Your Honour is anxious to get started with the next witness, and I understand he is ready to come. If I may just raise one matter, and perhaps Your Honours can give us an answer in due course, and that's simply relating to the conduct of proceedings. Now, we've lost some time this morning, more time on Friday, and again this afternoon. The result being that in the assessment of the prosecution, at least, it is unlikely that we will be able to finish both of the witnesses who are presently in The Hague by the end of the week as planned. So my first request is for an indication as to whether or not, if we do not finish that witness, if we will be able to continue into the next week to finish that witness before we break. The second one, which I imagine Your Honours will not be able to give an answer as readily, relates to the conduct proceedings thereafter. I did raise this issue a few days ago, Your Honours, but in the interim, I note that the defence in the Kenya 2 case have filed a request for an adjournment of that matter. Now, obviously, we cannot prejudge what will happen with that request, but if Your Honours would be predisposed to guide the parties as to what would happen should that request be granted, so that the necessary plans can be put in place to secure witnesses. As Your Honours know, there is approximately a 2-week lag time to get witnesses who are based in Africa or overseas to the court to testify. So there's some considerable logistical issues that will need to be addressed.
Thank you very much.
Mr. President, 2 matters with your leave. The first, if the court officer, with your permission, can give me some assistance. The microphone and audio system on this table is not working in the middle and on my side, so I can't hear the translation. So if somebody could come and fix one of these 2 devices, I'd be most grateful. Your Honours, when it comes to the schedule next week, of course we're in the court's hands, but we've been guided by the court schedule at the moment, and we have various team members have other commitments that have been planned because we had been led to believe the session would end on the 1st of November. Your Honours, from what I understand, and my learned friend Mr. Hooper QC and my learned friend Mr. Katwa Keegan, as well as the prosecution, no doubt, could speak to it. We anticipate this witness will take the bulk of this week. And it may well be, in those circumstances, the more prudent course would be to release the witness to come back later, because, of course, there is the option of starting maybe on Friday sometime, a bit of examination in chief. But on balance, my own personal view and my own submission would be, where possible, it's always preferable to keep examination in chief and cross-examination together, unless it's absolutely unavoidable. So my submission would be the witness could be returned and no need to keep the witness unnecessarily in The Hague until the current witness is finished.
Your point is that beyond the 1st of November, you have other commitments you've made in the meantime that may not allow you to continue beyond
Yes, Your Honor, of
that.
course, we will endeavour to accommodate and comply with whatever directions of the court, but we have planned certain, amongst both teams, I think we can speak for both teams here, certain discrete investigative activity and other activity as well that would put us in hardship. Your Honor, in relation to the second aspect and the court calendar, Your Honor, that's a matter that the court will decide in due course, but for my part, on behalf of Mr. Ruto, the court have been well informed about our preparedness to start this case and the need, our original request, based upon the judgment of all counsel involved, that we needed until November. Now, Your Honours, complying with the court's order, as we have, we factored in that during certain breaks, various very necessary investigative activity would be carried out. And so actually we need those court adjournments to do essential jobs that actually should have been done before trial started but haven't. So Your Honour, I'd ask that to be borne in mind. It's not a question of simply, of course, filling the slots because something may or may not happen.
Why don't we not, let's proceed this way. The prosecutor has raised this matter and put it on the table, and he did not require a ruling immediately.
I'm grateful.
Why don't we, as it were, put it on the bring up matter so that we can later on bring up that matter,
So be it.
especially in light of the application I understand has been made in the complainant case
Indeed.
for an adjournment. So if that is resolved either way, we may have to take up what happens with our own case in here.
I'm grateful. We'll be so guided.
Why don't we do that and then proceed with calling this witness? Yes, we have lost some time discussing necessary procedural issues that we need to take care of.
Mr. President, I just wanted to be sure that you will hear me before any decision is made on that issue of extending the time.
We're not making any decision.
Most
That's what I'm saying.
Thank you, Mr. President.
Can we bring the witness in now? Blinds down and the witness called in, please.